Hi everyone, my name is Alghoul. As you know from our Facebook page, we are giving and providing some videos about explanation, whether for immigration and other areas as well. And you also can see me on the Arab immigrants as well for some of the immigration questions and answers in Arabic. The reason why we wanted to do this in English is because I think it's important that we attend to all our audiences, whether they speak Arabic, English. That's the only two languages I know anyways, so we're going to be focusing on English as well. Today's topic is going to be about, it's going to be very short, it's only 15 minutes. It's going to be about the wells and the importance of having a well. I'd be more than happy, and as I indicated in previously in different communities and organizations, to speak about this in person and answer any questions that the audience might have. I think it's very important for people to understand why wells are needed in Canada for any person. What does it mean to die intestate without a well, and what's the consequences of that if you have younger children, or wealth that you might think that would be disputed over, and which might be heavily taxed as well after you're leaving us. So let's start very quickly by saying, what is a well? A well is defined in the law as the voice from the grave of the person who is giving the well. So it is the opportunity for someone to try and talk about what they wanted their estate, their remains, which is their body, and also the people that he leaves behind to be taken care of. So the will is important. Why? Because there are certain things, if you don't actually indicate what you needed to be done in your will, it will be decided on your behalf without your wishes being looked after. The will is not that difficult of an instrument. The will actually can be done usually in less than a week with any lawyer. He or she would be meeting with you initially, taking some information about your situation, your husband or wife situation, or common law situation as well. Preferably, we like to have both couples done at the same time, so that you can have different wills as to how you want your wealth to be dealt with, but you have to have the same when it comes to the children. How do you need your children to be looked after? For example, like if you're deciding on a guardian, you cannot have the husband saying, I want Mike to be the guardian of my children, and then the other person says, the wife or the partner saying, I want Jason to be the guardian of my children. You cannot have two conflicting. So there's still certain things that the wills of the couple needs to be aligned with. Other things, such as how you want to dispose of your money and so on, it doesn't have to be. In your will, you can actually also decide to talk about special gifts, like if you have gold or coin collections or stamp collections, you can give this to a certain person. Now, when I'm talking about the will, I'm distinguishing between the Canadian will, or the Arabic well, or the Islamic well, or the Orthodox well, or the Christian well. I'm focusing only on the Canadian well. So the question that I get from people is, can you actually combine a well that has both a religious flavor into it as well as make it legally, Canadian legally? The answer is yes, in most of the cases, to a certain degree, where you cannot take the rights from your spouse or common law partner away from them in case of inheritance. So both of the husband and wife should be in agreement as to how their share that they're supposed to leave is decided on their behalf. What I mean by that is, the Canadian law says that if you die when you have a common law or a partner, then they should be receiving 50% of your wealth if it's accumulated during the marriage or during the relationship where it's a common law relationship. So unless the spouse himself or herself decides to give that right away and have it distributed in a different way, when both of them consenting without any pressure, duress, or threat, then the normal would be that they would get 50%, and then the person who's dying can decide how the other 50% will be dealt with. But if both couples are in agreement how her estate or his estate will be dealt with in the case of two wells, but for the same couple, then that's a different situation. I don't want to go into details, I don't want to confuse everybody, but let's talk quickly about the parts of the well. The first part of the will is the testator or testatrix. So this is the person who actually is saying the will. So let's take me for an example. So if I am going to give a will that I am a testator because I'm a male, so the testator, a female with testatrix, the testator would say that I want, for example, my remains, my body to be, because I'm a Muslim, I want it to be buried according to the Islamic law, which would be mean that would be washed and wrapped and buried instead of incriminated, for example. You can decide as to what your wishes of your body to be done in the way you want it as well. Now let's keep something in mind. Very important thing in mind, most people don't know about, is that your remains after you die is not yours anymore, because you are not a person under the eyes of the law. So once you die, you cannot control your remains. The remains becomes the property of the country, or in this case the crown. But you can still say, I would like my remains to be dealt with in a certain way, provided there are no things that will prevent the government from doing its duties. For example, if you're murdered or if you're poisoned, so you cannot say, I don't want my body to be dissected to see what's going on, or to be under certain tests. So that would be a conflict. But in most cases, you can decide how your remains would like to be dealt with. The second part is the executor or executrix, again male and female. The executor or executrix is the person who decides, but who reads your will and talks to the beneficiaries or to the other people, or deal with your taxes or deal with your loans, how you need your estate to be dealt with. So they are the executor of the will. You can name more than one person. You can say, I'd like to name Mike. In case if Mike is unable or unwilling or is not available, then it becomes Jason in this case. Or it could be Muhammad and then, Fatima. Whatever. They go in order if they are not available or unwilling to continue to be the executor. The third part would be called the beneficiaries. The beneficiaries, very simply, are the ones who are in the receiving end of your estate. Of course, you have to take care of your taxes first, your debts first, and then the remains of your estate is dealt with in a certain way. The beneficiaries receive the net of your estate after you've already given the special gifts away. So if you are giving your gold to your daughters, or your coin collection to your son, or your car there's a certain way, then they receive the rest of it and they deal with it as you mentioned it in your estate, in your wealth, according to your estate division. So the beneficiaries could be minors, and they could be also older people. If they are minors, usually the money or the wealth would go into the custody or in the trust of someone who is called the guardian, or it could be with the executor until such time when the minors are older, 18 years old. Or you can even in your will say that I want the beneficiaries not to receive the will until they're 22 years old or 21. It's your will. There is no obligation on you. You can say, I think my children will waste their wealth if they receive it at the age of 18. So I want them to use some of this wealth for their education, for their livelihood. That's not a problem, but not to have an absolute use of the estate until they're 22, for example, when I know that they are mature and so on. So that's called the beneficiaries. Your beneficiary could be also non-related to you. You can also name anybody as a beneficiary. It could be a non-for-profit organization, for example. You can say, I want to have 1/3 of my estate to go to any organization which is non-for-profit, for example, or to any person that is not even part of your family, which is fine. It is your will. You can decide with it what you want. Now, some of you might say, well, that's not Islamic, or that's not Catholic, that's not Orthodox, that's not Jewish. That's different. So if you want to incorporate your religious needs into the will, it has to be tailored by a very professional and experienced lawyer who can, or she or he can, make sure that the will is legally binding, and at the same time have as much as possible your religious flavor into it if you need to. If you are not concerned about the religious flavor, but you want to add something that might still contradict with the law, the lawyer would be advising you what is and what is not allowed and what is prohibited as well. The fourth part is the guardians. So we talked earlier about how if you have minors, if you leave minors behind you, what's going to happen? Well, there has to be a guardian who would be looking after them. If you don't name a guardian, then the crown or the country would automatically assign the children to foster homes, for example. Many of us will have issues with that because maybe the children, if they have more than one child, they might be divided into different foster homes and things like that. You might have relatives who would like to look after them, but they are not named in the will. So the typical thing that's going to happen is that, of course, other than the spouse, the typical thing that's going to happen is that these children will be taken from the custody of the people who are still alive, provided they're not the parents, and be given to the foster homes until such time when the relatives can apply for a guardianship under the courts. That can take months, sometimes even longer. So imagine in my opinion, the devastation that can happen when you separate siblings from one another, when they are isolated and things like that. That's very difficult. It's a service that is provided for people who don't have relatives here, who don't have friends who can look after their children as to their wishes. It's a great service, of course, otherwise our children would be in the streets. But if you have another option, if you have another way to ensure that your children are still kept together in a good home the way you want them to be raised, you should indicate that, and that's done through a will. So the guardian, the person that you choose, again, it could be in sequence the same as the executor or the executrix. So the guardian, you can say, for example, I want this person to be the guardian of my children. Of course, you and your spouse have to agree. Both parents have to agree on the same guardian. If they are not available or unwilling and so on, then this person becomes the guardian. You can name as many as you want. Usually, typically, it's 2 or 3 people are named in the will. So what happens in case of many of the immigrants who have their family overseas and they're here on study visa, or they're new immigrants and they have nobody else? Well, you need to be very careful in naming people who are outside the country as the guardian of your children without having a substitute guardian or without having a temporary guardian in the country. Because what's going to happen is they cannot just fly in from Philippines or any other country of the world and take guardianship immediately of the children. That's not going to happen. What our country have to make sure this guardian person, is free of criminal issues, free from child molestations, able to and mentally able to take care of these children if they apply, and so on. So you need to make sure there are someone in between this transition stage. And again, this is something that your lawyer would be discussing with you and so on. And of course, there are many areas in the world that you need to address. If you have corporations, for example, if you have debts, for example, if you have tax issues, if you have and so on, all these things, all these areas needs to be dealt with and addressed in the will as well. Therefore, I ask you that if you do a will, I would ask you that you would it's recommended that you revisit your will every 2 years or every 3 years. Just go back and read it again. Make sure that there is nothing that needs to be changed or adjusted. You don't know what's going to happen with your, once you write the will, and it's a very unpleasant subject to talk about anyways or to revisit, but once you write it, you want to try to bury it away from you. I understand that, but it's very much recommended to do so. In fact, the practice in our firm, we kind of remind you after 2 or 3 years to revisit your will and see if things has changed in it as well. So I don't want to go through the many areas that can be discussed in the will. This is the job of your legal counsel to go through and to do with you. But I would just want to focus and remind you that it is extremely essential and important if you are a resident of Canada to have a will and to have it in a safe place. Now, be careful not to put your wills in your bank box or the jewelry box in your bank, because nobody else have access to that. So you're gonna get stuck there, and we need a court order to try and open that for you. So the wills is only valid if there is the original will. I cannot make copies for you and give it to you and you can use that in court. You have to have the original will. The person have to have the executor have to have the original will when they are trying to do the will. When you are writing your will, the lawyer and the witnesses have to make sure that you are without any pressure against you, duress. There is no any you're in mental ability to do the will and so on. There are certain things we look for to make sure the will is done properly. If you're doing it with your wife, my general practice, for example, is to separate you when I'm talking to each one of you and things like that. So I hope this will be helpful. I hope that you have gained some information about the importance of the will. If you are within Manitoba or within Canada and you view this video from our Facebook website, and if you want me to, I'm licensed in Ontario, for example, and British Columbia as well as Manitoba. If you'd like me to travel to your jurisdiction, even if it's Saskatchewan and so on, just let me know with my office. Book the time. Give me about 3 weeks to 1 month in advance, and I'd be more than happy to come over to your community, provide the lecture in person for your community, regardless of which community it is, and answer any questions that you might have for me, because I think it's an essential tool, an essential document to have if you are a resident of Canada again. And I wish everyone the best. I wish you all a long, happy, healthy lives, and I also wish that whoever you leave behind will always remember you well, and be very happy that you looked after them when we move to the next stage of our beings. Thank you very much and take care. Bye-bye.